Good evening, respected panelists and the viewers of Law Advice. Uh, while Honorable Justice Kishore is having a little technical issue, I reckon. Uh, Let me just start by, I think, we've all been given a little backdrop about these three new laws that are set to change the course of criminal dispensation in India. The two primary things that, and what I thought is the topic for the day is the difficulties that are being faced by legal practitioners, the students, the honorable judges, and the common man and such, insofar as implementation of these laws are concerned. Now, as we are all aware that the central government has just notified these laws, but there is a respective clause in all these three acts which says that the respective provisions of these laws would come in at a subsequent date, as and when they are notified by the central government. And that is yet to see the light of day. And so we still essentially going by the Indian Penal Code, the CRPC, and the CPC. So my effort here would be, that it's like an ocean in front of us at the moment, uncharted territory, and I wouldn't say a detailed, but rather casual, scrutiny of certain provisions of these particular laws that I thought was important for day-to-day practitioners. I thought that I should address my limited understanding of these provisions to you all. Now, very interestingly, when we open the Bharatiya NYAYA SANHITA, which is to replace the Indian Penal Code, and I draw specific reference to section 1(5) of the particular act. Now, a very interesting preposition for the first time is mooted by the Indian legislature, where they propose that for any offense by an Indian citizen, even if it is committed outside the territorial jurisdiction of India, he could be tried under Indian laws. Now, what is very perplexing is there is a concept of certain international law, private international law, where we recognize that an offense committed in a certain country would be dealt with by the laws of that particular country. And that would be one of the fundamental principles of sovereignty, which is again recognized by the Constitution of India. Now, the legislature in its own mind, and I'm sure there have been very active minds working on it, has brought in a provision, and it says, and since it's a new provision, I'll just quote from here, and I quote. This is section 1(5). It says that the provisions of the Sanhita apply also to an offense committed by A, any citizen of India in a place without and beyond India. So we are looking at a concept of where I, as an Indian, am to commit an offense outside the territorial limits of India, and B, they say, any person or any ship or aircraft registered in India, wherever it may be, any person in any place without and beyond India committing offense targeting a computer resource located in India. And then there's an explanation which says, in this section, the word offense includes every act committed outside India, which if committed in India would be punishable under the Sanhita. So for the first time, we're looking at a concept of where an Indian national commits an offense outside the country, besides prosecution in the country where the offense is committed, there would also be it would also be an offense, and there would be investigation and trial under Indian laws. Now, I don't know to what extent this would hold water subsequently. That we'll have to examine the subsequent court, but this is what the legislature has brought in. Now, if we go into the Bharatiya NAGARIK NYAYA SANHITA, which is set to replace the Code of Criminal Procedure, there are some very interesting thoughts that came into my mind. I'm sure all of you must be watching the various opinions of experts on this. Now, what? Let's just take two provisions, for instance. Now, the first provision, which I thought was important for legal practitioners, and it is bread and butter for a lot of people, is anticipatory bails. Let's just talk anticipatory bails. Now, anticipatory bails under the present Code of Criminal Procedure is dealt with by Section 438 of the Code of Criminal Procedure. That is sought to be replaced by what would now be Section 482 of the BNSS. I'll refer to it as BNSS. Now, there are substantial changes that have happened in the BNSS from what was there under the CRPC. Now, what they have done is, earlier under the CRPC, there was a mandatory requirement of hearing the prosecution so far before a final order of bail is passed, anticipatory bail is passed by a competent court. Unfortunately, under the new laws, probably the legislature or the select committee to whom it was referred lost track of the fact that these certain provision which was brought in by way of an amendment amending Section 438 subsequently requiring mandatory notice to the prosecution has again been left out insofar as the BNSS is concerned. So there would be instances where I would be accused of a certain offense committed in place A. I would go to place B and I would obtain some kind of bail from there without the prosecution of place A, which is the competent investigating agency, actually being served notice by the court. Now, I would like to share an anecdote of a certain case that we did very recently, and the Honorable Supreme Court has delivered a very lengthy judgment insofar as this aspect of the matter is concerned. It is a matter called Priya in Doria versus State of Rajasthan. Now, there what had happened is an FIR was filed in Rajasthan. The accused family used to stay in Bangalore. So they approached the Sessions Court in Bangalore and obtained an anticipatory bail from Bangalore in respect of an offense which was registered in Rajasthan. That matter came to be challenged before the Honorable Supreme Court, and the Honorable Supreme Court, while examining the detailed law on the issue, has given certain findings. One of which is that without hearing the prosecution, any orders could not have been finally passed. Now, the BNSS somehow has lost track of this, and what has happened is now the provision of the BNSS Section 482 as it stands does not require the mandatory hearing of the investigating agency of the place where that or the state where the offense has been registered. In my considered opinion, this would lead to manifest miscarriage of justice. So while the legislature was indeed amending the law to make it more compatible to Indian circumstances, what it has essentially left out is, and that's very unfortunate because what I'll say subsequently also would probably reflect this, that the pronouncements of law on the issue have somehow been lost track of by the legislature. So this is something that would create a lot of confusion amongst courts, counsels, and clients, litigants all across the country. Now, one very significant introduction in the BNS is the introduction of a certain provision called Section 69, which says that engagement of anybody in any kind of personal sexual relations with a person on the pretext of marriage would be a punishable offense, and it would entail serious punishment. We are all aware, as I'm sure the group which we are addressing this webinar on is a group of people who are closely associated with law, if not lawyers and judges, students of law. Now, we're all aware that in India, there's this sudden surge of unfortunate false allegations in this regard being made, and frivolous complaints being lodged with the police and courts all across the country on this limited pretext that, yes, me and he were having this kind of a relationship. For some reason, the relationship went sour, but one of the aggrieved parties goes and says that, no, there was this intimacy between us, but the intimacy was on the pretext of marriage. Now, the Honorable Supreme Court as well as the various high courts of the country have repeatedly cautioned the investigation, saying that there has to be a detailed scrutiny regarding the conduct of the parties. And certain parameters have been set insofar as investigation into these kind of cases have been concerned, because there has been this trend. There was a time when the formulation of Section 376 was on the premise that once a lady comes out of her house and actually makes an allegation of rape against somebody, it had to be the gospel truth, because an Indian lady will not come out on her own and make some kind of an accusation like that. It was on that premise that this law was existing. With the evolution of time, what has essentially happened is there are repeated judicial pronouncements where this provision has been manifestly misused by people for their own personal gain. And certain parameters have been set by the courts, saying that when you are investigating this kind of offense, these checks and balances have to be examined before you actually go forward. Unfortunately, now for the first time in India, Section 69 of the BNS is introduced, which becomes a punishable offense. And the safeguards which have been laid down by judicial pronouncements, unfortunately, in my humble, in my considered view, has not been taken note of by the legislature. So again, we go back to square one. As I said in the beginning, it is an uncharted territory. And every provision of this BNS or BNSS would again have to be examined on the touchstone of judicial scrutiny. Another very interesting fact, which I thought that what was the need of bringing in this kind of a law, replacing something which is 200 years old, was to avoid frivolous litigation. One of the things plaguing the Indian judicial system is there is a lot of frivolous litigation happening all across the country. And that tantamounts to courts being burdened, genuine cases suffering, litigants suffering. And what was made famous by a movie of Sunny Deol, Tariq Pe Tariq, that is something which has become part and parcel of our Indian judicial system. Now, if we were to change the law and bring in something new which could substitute what is the present position of law, we had to discourage people from initiating frivolous litigation or litigation with some malified motive. Now, the only provision under the IPC that had to deal with this was perjury, and we can go back to section 193 of the IPC. Now, what is shocking is, if we are trying to bring in a law which would deal with this, I'm sorry. Now, section 229 of the new BHARATIYA NYAYA SANHITA, which is to replace the IPC, again deals with perjury. Unfortunately, the punishment as was prescribed under the IPC has been reiterated under this new BNS. So in essence, we are not looking for anything new. And as the saying goes, it is essentially old wine in a new bottle with a little bit of packaging. Now we'll have to see how far this packaging will hold water in proceedings before courts, and the courts would have to spell out regarding the constitutionality or otherwise of these laws. My closing remarks would essentially again be this, that we are on uncharted territory. We don't know where we are going. The central government is yet to even notify the dates under which these provisions would come into effect. And so therefore, we are, in a state of fix insofar as legal practitioners are concerned. We are in a state of fix, not knowing how it is going to be implemented, when it is going to be implemented, and what would be the course that would be appointed by the government of the day insofar as implementation of these laws are concerned. And before I end, there is a little something, because I personally come from the Northeast. Now, as I told you all before this little webinar, I was just taking time out to look at where the BNSS, or what is the Criminal Procedure Code, how it is to be implemented. Now, very interestingly, and I think this would interest my friends from the Northeast. Now, it says, section 1 says that it is applicable to the whole of India. Now, section 1.2 says it does not apply to the state of Nagaland. Now that has been the consistent position of law in view of the sixth schedule to the Constitution of India. Now, subsection B of clause B of subsection 2 of section 1, again, interestingly says it does not apply to the tribal areas. Now, the tribal areas are defined by the Constitution, Schedule 6, Para 20, which would also include certain portions of Mizoram, certain portions of greater areas of Meghalaya, and of the undivided Assam, because the cutoff date as per the new act is 1972. So we would all recollect that 1972 is when the Reorganization Act came into being, and the erstwhile undivided Assam gave birth to at least 3 states. We're talking about Meghalaya, we're talking about Mizoram, and they are all having tribal areas. Now, certain parts of this law, specifically Chapter 9, Chapter 11, and Chapter 12, which deal with public law and order, have been left out of operation insofar as the northeastern states are concerned. And we would all be aware, especially in view of the recent spate of violence in the state of Manipur, which again has tribal areas, as to how public order is to be governed. So these ambiguities in the law, I think, would be best dealt with by the government of the day. And, as a council, I can only say this, that, all these provisions would have to be tested one by one, because what this law has essentially done, and that's my personal opinion, it's set to replace something that has crystallized over 200 years. So 200 years earlier, some law was made by Lord Macaulay. With the legal system comes into place. Time and again, every full stop, every comma, every colon appearing in every provision has been examined by the courts, interpreted by the courts, where there was a lacuna that has been filled in with judicial pronouncements. And we have a certain system in place. Now that is sought to be replaced by this new law. So I think it's a little early in the day to comment any further on this.